Welcome back to this course on copyright and related rights law. In the previous 4 sessions, we have discussed infringement of copyright under Section 51 of the Indian Copyright Act. We have also discussed how the Indian Supreme Court in R.G. Anand versus Deluxe Films has explained infringements as they occur with respect to non-literal features of a work. We have also understood how websites such as torrent websites are in fact hubs of online piracy. In today's discussion, we are going to consider whether subconscious copying is something that can amount to infringement in a work. After we are done with this particular understanding, we will then proceed to solve certain problems. Let us ask ourselves, when we looked at Section 51, was it provided under Section 51 that if a person is unaware of there being a copyright in some prior existing work, that such a person will be given a clean chit? There is nothing like that under Section 51. There is a provision which is contained within Section 51, Clause A, Subclause 2, which we had discussed as being applicable to that person who is providing his platform for profit and where communication of a work or performance has taken place, of which he had no awareness, was an infringement. Apart from this, there is nothing in Section 51 which suggests that simply because a person is unaware of an existing copyright, he should be given a clean chit. To supplement this understanding, let us consider Section 55 of the Indian Copyright Act, which provides for civil remedies. In this provision, it is clearly provided that if a person is unaware of copyright in a work and is being alleged to have infringed that work, the remedies that will lie against such person can be limited, but it does not eliminate the infringement itself. Please understand that in cases of infringement, generally, all remedies such as the remedies of injunction, remedies of damages, all of these will be available against the infringer. But in the proviso to Section 55, Clause 1, if a person can show that he was unaware, then the relief is limited against such an infringer to an injunction and a portion from the profits that are received by such infringer. Let us consider, when an infringement action is undertaken against an individual, what is it that the claimant has to prove? Quite naturally, because the claimant is saying that his copyright in a particular work has been infringed, he will attempt to show that he has a valid copyright. What does it mean for a person to say that he has a valid copyright? It means that he has created his work independently and it is not copied from someone else. He would also show that the other person has copied the work. In other terms, he would show that there was access that this defendant is having or had with the plaintiff's work, and this access is something that will defeat any claim that is made by the defendant with respect to independence of his creation. Let us recall Session 21, in which we discussed what original means. In this particular discussion, you would recall we had discussed the term original and its dimension as an independent creation, meaning that it is not copied from elsewhere. Therefore, the question that we had asked was, can there be identical or substantially similar works which are independently created? You would recall, we had answered this question by saying that it is possible that two people who are separated by geography but exposed to common phenomena are able to arrive at a substantially similar expression. While this is possible, but practically for two people to arrive at a substantially similar expression would indicate that there might be some kind of access. Nevertheless, if upon the claim being made by the copyright holder that his is a valid copyright, that the defendant has had access to the work, what does the defendant do? The defendant would attempt to show that the subject matter is uncopyrightable. Second, he would try to show that there is a common source for both the plaintiff's work and the defendant's work. And third, he would show that he had made his work independently. Let us consider how the work which is being claimed to have copyright in it can be shown to be uncopyrightable. We had discussed how titles which are claimed to be literary works are not considered as subject matters which can have copyright in it. What about common source? If there is a common source based on which two works are existing, then as we had discussed in R.G. Anand versus Deluxe Films, there would be a lot of similarities between these works, and such similarities could in fact show that there is in fact a lot of commonality in that expression, and none of it is in fact eligible for protection. In terms of subconscious copying, we are considering a question whether, in claiming that the defendant has independently created a work, has he in fact used subconsciously an original work? Is that something that can be considered as a defense? You must have noted that in such a claim there is a flaw, and the flaw is, how can a creation be independent if it is in fact based on a pre-existing work in which copyright is existing? This reasoning is the background to how subconscious copying is an act that can amount to infringement. Let us consider a case that arose in the United States. This is Bright Tunes Music Corp versus Harrisongs Music Limited. This case involves a member of the popular band called the Beatles, George Harrison. George Harrison had composed a work called My Sweet Lord, which was recorded in the year 1970. But George Harrison's composition was similar to a prior existing recording on a composition called He's So Fine, which was composed by Ronald Mack. The years that separated He's So Fine and its publication and Sweet Lord, could those years that had passed be considered as a ground for forgetting that copyright existed in a particular work, or that the work was there at all? Such was the scenario that occurred in this particular case. At the time at which He's So Fine was published, it became the number one listened to music for several weeks in both US as well as in England. George Harrison admitted to know about He's So Fine, but at the same time, the claim that was being made was that he had independently composed My Sweet Lord. This is what the US court is saying. The composer, in seeking musical materials to clothe his thoughts, was working with various possibilities. As he tried this possibility and that, there came to the surface of his mind a particular combination that pleased him as being one he felt would be appealing to a prospective listener. In other words, that this combination of sound would work. But is there a reason why he would feel that this combination would work? Could it be that in his subconscious he knew that this combination had in fact worked, but his conscious mind did not recollect this particular fact? The court continues in saying, having arrived at this pleasing combination of sounds, the recording was made, the lead sheet prepared for copyright, and the song became an enormous success. Now, did Harrison deliberately use the music of He's So Fine? The court is saying that they don't believe this to be the case. But nevertheless, it is clear that My Sweet Lord is the very same song as He's So Fine with different words. This is, under the law, infringement of copyright and is no less so, even though subconsciously accomplished. Therefore, this particular case demonstrates to us that if access to a work can be shown, then even if the artist is after many years creating a work and having done so says that he does not recollect the original work, that cannot be used as a defense. It will be considered as an infringement. Cases pertaining to subconscious copying have arisen in the US, and this particular case is very significant in our understanding. Let us move to the next segment of our course. In this particular segment, we are going to be solving problems. These problems relate to real life situations. In solving these problems, use your knowledge that you have accumulated over the previous sessions, spanning subject matter understanding, copyright subsistence on application of originality, exceptions against such copyright, and infringement actions. In doing so, you will be able to use copyright law in your daily lives. Feel free to pause the video when I read the problem and try to solve the problem yourself before I solve it. Let us look at the first problem. A and B's wedding video, which was shot in Delhi in 2025, was made at their instance by DEF Studio. DEF Studio was given rupees 4.5 lakhs by A and B for this purpose. A and B decide to put up their wedding video on YouTube, where it becomes a hit. They make revenue from YouTube. Is DEF's copyright violated? Let us see. What is the work? We understand that the work is a cinematograph film. Who is the author of the work? The author of the work seem to be A and B. Why is that? Despite the fact that DEF Studio has made this video, it is A and B who have taken the initiative and the responsibility for making this film. And therefore, if we look at section 2 clause W, it says that the producer in relation to a cinematograph film is a person who takes the initiative and responsibility for making the work. Therefore, who is the first owner? Being the author of this wedding video, A and B are the first owners. How do we know this? Section 17, which talks about first ownership, very clearly provides that the author of a work shall be the first owner of the copyright therein. Even if we say that A and B are not the authors, even in that case, upon application of section 17 clause B, it says that where a video is made at the instance of a person, then such person who has made valuable consideration will be the first owner. And therefore, it will be A and B who will have copyright over the cinematograph film. As you understand, once it is determined that the person has copyright under section 14, then they can do what they wish with that work. So to upload that work on YouTube is completely their prerogative. DEF has no claim. Let us look to the second problem. X is an Indian national who visits Brazil often for business trips. He purchases inexpensive, illegitimate copies of books from street vendors in Brazil. He uses them for his personal purpose in India. In 2025, on a visit to Brazil, X likes a book written by Y, an Indian author. The book is selling for a lower rate in Brazil than it is selling in India. X bought 200 copies for the purpose of selling them in India. Is there going to be a violation of the copyright of Y, where X imports these copies and then engages in sale? Let us first understand what is the work. It is clear that the work is a literary work. This is a book which has been authored by Y, an Indian author. Who is the first owner? Since this fact scenario does not tell us about any publisher, we will go with section 17, which says author is the first owner. And therefore, Y is the first owner. Is there any exception that we must consider? Because if not for any exception, will this not be infringing? We have discussed that importation into India of copies which are more than one will amount to infringement. We had also understood how even legitimate copies which are purchased in foreign countries and brought to India could be held to be violative of the issuance of copies right under section 14 Clause A, subclause 2. Therefore, these are illegitimate copies, and any importation of these copies into India will be necessarily an infringement. There is no exception that is carved out either under Section 52 or in any other part of the Copyright Act that can validate such an importation or sale. It will be infringing under Section 51. We will continue this exercise of solving some problems in the next session as well. Thank you for joining me. See you all in the next session. Thank you.